Something extraordinary is happening in Washington right now. A law that passed Congress with overwhelming bipartisan support, 427 to 1 in the House, unanimous in the Senate, is being openly defied by the very administration that signed it into law. We're not talking about a minor procedural dispute. We're talking about the Department of Justice arguing, in a federal court filing, that no court in America has the authority to enforce the Epstein Files Transparency Act. Think about what that means for a moment. A law signed by President Trump in November 2025, requiring the release of all files related to convicted sex offender Jeffrey Epstein within 30 days, has now become the subject of what can only be described as bureaucratic resistance of the highest order. As of January 2026, less than 1% of the files have been publicly released, despite the December 19th deadline having passed. What makes this particularly striking is the legal argument being advanced. The Justice Department formally admitted in federal court that no court can force it to release the Epstein files or compel compliance with the Epstein Files Transparency Act. The department is essentially claiming that while Congress can pass laws and presidents can sign them, there's no mechanism to actually enforce this particular statute. Representatives Ro Khanna and Thomas Massie, the bipartisan architects of this legislation, have asked a federal judge to appoint a special master to oversee the process, but the DOJ maintains these lawmakers lack standing to intervene. This raises profound questions about accountability, the separation of powers, and what happens when an executive branch department decides a law is, in practice, unenforceable. Now, to understand what's really happening here, we need to step back and examine the extraordinary sequence of events that brought us to this moment. The Epstein Files Transparency Act wasn't some obscure piece of legislation quietly tucked into a larger appropriations bill. This was a law that commanded near universal support in Congress. Think about that for a second. In an era when Congress can barely agree on naming a post office, this bill passed the House of Representatives with a vote of 427 to 1. 427 to 1. Only a single member voted against it. The Senate didn't even bother with a recorded vote. They passed it by unanimous consent the very same day. This is virtually unheard of in modern American politics. When was the last time you saw Democrats and Republicans, progressives and conservatives agreeing on anything with this level of unanimity? And yet, here we are, weeks after the statutory deadline, and the overwhelming majority of these files remain hidden from public view. The law itself is remarkably straightforward in its requirements. It mandates that the Attorney General release all unclassified records relating to Jeffrey Epstein within 30 days of the bill's enactment. The law is quite specific about what must be released. It covers all investigations and prosecutions involving Epstein. It includes flight logs and travel records from any aircraft, vessel, or vehicle he owned or operated. It demands the disclosure of individuals and entities connected to his criminal activities, including government officials. It requires the release of any immunity deals, non-prosecution agreements, plea bargains, or sealed settlements. It even calls for internal Department of Justice communications about decisions to charge or not charge Epstein and his associates. The legislation explicitly prohibits withholding or redacting documents based on embarrassment, reputational harm, or political sensitivity, even when it involves government officials, public figures, or foreign dignitaries. The only permissible exceptions are narrowly defined, protecting the personal information of victims, safeguarding active federal investigations, and preserving properly classified national security information. Everything else was supposed to be made public in a searchable and downloadable format by December 19, 2025. That deadline came and went. On the day the files were supposed to be fully released, the Department of Justice provided only a partial dump of heavily redacted documents. The files that were released created their own controversy when it was discovered that the redaction techniques were faulty, allowing users to recover completely unredacted portions of the documents over several days. These recovered sections contained significant findings about members and techniques of Epstein's trafficking operation, not merely the personal information of victims as the law permits to be redacted. Among the most disturbing revelations was an FBI tip concerning allegations involving Trump himself, though we must be careful here because these are unverified tips that appear in investigative files, not proven facts. But the point is that the public only learned about these details because the Department of Justice failed to properly redact the documents it chose to release, while simultaneously withholding vast quantities of other materials entirely. By early January 2026, the scope of the department's non-compliance became clearer. In a court filing, the Justice Department acknowledged it had released approximately 12,000 documents comprising roughly 125,000 pages. That might sound substantial until you learn there are more than 2 million documents potentially responsive to the act still under review. Some reports suggest the actual number could exceed 5 million pages. To put this in perspective, the department released less than 1% of the material that should have been made public by the statutory deadline, 1%. And remember, this deadline wasn't advisory or aspirational. The law states explicitly, not later than 30 days after the date of enactment, not whenever it's convenient, not when the department finishes its internal review process. 30 days. The response from lawmakers has been swift and bipartisan, which again tells you something about how serious this situation is. Representatives Ro Khanna and Thomas Massie, the Democratic and Republican co-sponsors of the legislation, have gone beyond mere criticism. They've taken the remarkable step of asking a federal judge to appoint a special master to oversee the release process. In their letter to Judge Paul Engelmeyer of the Southern District of New York, they didn't mince words. They wrote that they have urgent and grave concerns about the department's failure to comply with the act and believe that criminal violations have taken place in the release process. Let me repeat that. The lawmakers who wrote this legislation believe criminal violations have occurred. They stated flatly that the Department of Justice cannot be trusted with making mandatory disclosures under the act. This isn't partisan political theater. This is a Kentucky Republican and a California Democrat jointly declaring that they have no confidence in the executive branch's willingness to follow the law. Their specific concerns are detailed and damning. They noted that the department has failed to provide the required report to Congress within 15 days of completing the release, which means there's no authoritative accounting of what records exist, what has been withheld, or why. They pointed out that some files were released on December 19th and then mysteriously removed from public access without explanation. While protecting victims is absolutely appropriate and required, the department's own statements acknowledge that information victims believed should have been redacted was nonetheless posted publicly, suggesting the review process was rushed and inadequate. Meanwhile, materials that should have been released appear to have been withheld or excessively redacted. Khanna and Massie specifically highlighted their concern that the department applied extensive redactions inconsistent with the Act's prohibition on withholding records to protect politically exposed persons. In other words, they suspect the department is using victim privacy as a cover for protecting powerful people, which is precisely what the law was designed to prevent. The department's numbers themselves raise troubling questions. Initially, officials indicated they were reviewing around 2 million documents. Then suddenly, after the deadline passed, they claimed to have discovered millions more. Khanna and Massie noted that because these figures are self-reported and internally inconsistent with prior representations, there's reasonable suspicion the department has overstated the scope of responsive materials, thereby portraying compliance as unmanageable and effectively delaying disclosure. This is a polite way of suggesting the department might be inflating the document count to justify its failure to comply with the law. Whether that's true or not, the optics are terrible. It looks like every time the department faces pressure to complete the release, they conveniently discover millions more pages that need to be reviewed. Now here's where the constitutional dimension becomes fascinating and deeply troubling. The Department of Justice has responded to Khanna and Massie's request for a special master by arguing that the court lacks authority to grant such relief. U.S. Attorney Jay Clayton filed a letter with Judge Engelmeyer asserting that the lawmakers don't have standing to intervene because they're not parties to the underlying criminal case against Ghislaine Maxwell. But this argument reveals something extraordinary about the department's theory of its own power. If the lawmakers who wrote the law can't enforce it, and the court can't oversee compliance, and the executive branch department responsible for implementation claims it can determine its own timeline regardless of statutory deadlines, then who exactly can compel compliance? The department is effectively arguing that while Congress can pass laws requiring disclosure and the president can sign those laws, there's no practical mechanism to force the executive branch to actually follow through if it decides the law is too burdensome or politically inconvenient. Representative Khanna pushed back hard on this characterization, stating that Clayton's response misconstrued the intent of their request. He emphasized they're informing the court of serious misconduct by the Department of Justice that requires a remedy, one they believe the court has authority to provide, and which victims themselves have requested. The purpose, he said, is to ensure the department complies with its representations to the court and with its legal obligations under the law. But the department's position raises a fundamental question about the separation of powers. If an executive branch agency can simply ignore statutory deadlines and refuse judicial oversight, what constrains executive power? This isn't a theoretical concern. We're watching it play out in real time with a law that received nearly unanimous congressional support and explicit presidential approval. The political dynamics here are particularly complex because this situation doesn't fit into our usual partisan narratives. President Trump himself said during his campaign that he would release the Epstein files. After initially opposing the legislation, he ultimately signed it into law and then claimed credit for it, writing on social media that he had asked House Speaker Mike Johnson and Senate Majority Leader John Thune to pass the bill. So we have a law signed by a president who campaigned on transparency regarding these specific documents, passed by overwhelming bipartisan majorities in both chambers of Congress, being systematically ignored by that same president's Department of Justice. The Attorney General, Pam Bondi, was appointed by Trump. The people making these decisions about withholding documents and slow-walking compliance are Trump appointees working in a Trump administration. This creates a fascinating question. Is the department acting contrary to the president's stated wishes, or has there been a quiet change in position now that the administration actually controls these files? The substantive reasons for the delay, as articulated by the department, center on the need to properly redact information to protect victim privacy. This is unquestionably important. The law itself recognizes this by permitting redactions of personally identifiable information of victims. No one wants to see abuse survivors re-traumatized by public disclosure of their personal information. But here's the problem with that justification. The law anticipated this exact concern and provided for it. The requirement wasn't to dump everything raw and unredacted. The requirement was to release the files with appropriate redactions within 30 days. If the department needed more time or resources to do this properly, the appropriate response would have been to request an amendment to the timeline or additional funding for the project before the deadline arrived, not to unilaterally decide the law's requirements don't apply because compliance is difficult. Moreover, as Khanna and Massey pointed out in their filing, the conduct by the department has actually caused serious trauma to survivors, not prevented it. When files are released with inadequate redactions, then hastily pulled down, then portions are withheld entirely without explanation, it creates uncertainty and anxiety for victims who don't know whether their information has been protected or exposed. A systematic, transparent process overseen by a neutral party would likely be less traumatic than the chaotic, opaque approach we've seen so far. The department's own admission that victim information was inadvertently posted publicly despite tens of thousands of manual redactions and quality control checks suggests their internal process isn't working well. An independent special master might actually help protect victims more effectively while ensuring the law's transparency requirements are met. There's also the question of what's actually in these files that makes the department so reluctant to release them. The law explicitly prohibits withholding documents based on embarrassment or political sensitivity. That provision was clearly included because Congress anticipated that powerful people might prefer these files remain hidden. The flight logs alone are of enormous public interest. Epstein's social network included presidents, princes, business titans, scientists, and celebrities. Some of these individuals may have had entirely innocent interactions with Epstein before his crimes became widely known. Others may be implicated in knowledge of or participation in his criminal enterprise. The public has a legitimate interest in knowing who was in Epstein's orbit and what investigators learned about those relationships. The immunity deals and non-prosecution agreements are similarly crucial. The 2008 plea agreement that allowed Epstein to plead guilty to minor state charges while avoiding federal prosecution for sex trafficking has been widely criticized as a sweetheart deal. The architect of that agreement, Alex Acosta, later served as Trump's Secretary of Labor before resigning amid controversy over his role in the Epstein case. What other deals were made? Who benefited from them? What evidence did prosecutors have that they chose not to pursue? The Internal Department of Justice communications are perhaps the most significant category of documents from a government accountability perspective. These would show how decisions were made about whether to charge Epstein or his associates, who made those decisions, what factors were considered, and whether improper influences played a role. This is exactly the kind of information the public needs to evaluate whether justice was served or subverted. The fact that the department seems particularly resistant to releasing this category of material is telling. It's one thing to claim that releasing victim information would cause harm. It's quite another to argue that releasing internal DOJ emails and memos about prosecutorial decision-making serves no public interest. Those communications aren't about protecting victims. They're about protecting the department's reputation and potentially shielding officials from accountability for their decisions. Let's also consider the broader implications for government transparency and the rule of law. If the Department of Justice can effectively nullify a statute by slow-walking compliance and claiming no court can compel it to follow the law's timeline, what precedent does that set? Could other agencies take the same approach with laws they find inconvenient? Could the Environmental Protection Agency decide that compliance with pollution disclosure requirements is too burdensome and simply release information at whatever pace it finds manageable? Could the Securities and Exchange Commission ignore statutory deadlines for financial disclosures? The entire regulatory state depends on the premise that when Congress passes a law with specific requirements and deadlines, executive agencies will implement those requirements in good faith. If that premise breaks down, congressional authority is effectively reduced to making suggestions that the executive branch can choose to follow or ignore. The standing argument advanced by the department is particularly troubling from this perspective. If members of Congress who authored legislation don't have standing to seek judicial enforcement of that legislation, who does? Individual citizens might lack standing because they can't demonstrate particularized harm. Victims might have standing to seek release of files relevant to their own cases, but not to compel comprehensive disclosure of the entire archive. The department's theory seems to create a zone of unreviewable executive discretion where laws can be nominally followed while being substantively evaded, and no one has the legal standing to do anything about it. This is precisely the kind of situation that should trigger serious separation of powers concerns. Congress passed a law. The president signed it. But now the executive branch is defying its clear requirements, and arguing courts have no power to intervene. That's not how the constitutional system is supposed to work. What makes this situation even more remarkable is the public's overwhelming support for release of these files. Polling conducted before the law passed showed more than 3/4 of Americans supported releasing all Epstein files with victims' names redacted. This wasn't a partisan divide. Republicans and Democrats both wanted transparency. The near-unanimous congressional votes reflected genuine public consensus. So we have a situation where the public wants these files released, Congress overwhelmingly voted to require their release, the president signed the law mandating their release, and yet the executive branch agency responsible for implementation is refusing to comply with the law's clear requirements. If this doesn't constitute a crisis of democratic accountability, it's hard to imagine what would. The path forward remains uncertain. Judge Engelmeyer has taken the unusual step of ordering Khanna and Massey's attorneys to file their request publicly and has given the department until a specific deadline to respond. This suggests he's taking the matter seriously and hasn't summarily dismissed the idea of appointing a special master. But even if he agrees that such oversight is necessary, the department could appeal that decision, further delaying any meaningful progress toward compliance. Khanna and Massey have also threatened to pursue inherent contempt proceedings against Attorney General Bondi, which could potentially fine her thousands of dollars per day for non-compliance. But that would require enough House members to vote for such a measure, and it's unclear whether sufficient Republicans would be willing to hold a Trump appointee in contempt, even for violating a law they overwhelmingly voted for. What we're witnessing, fundamentally, is a test of whether statutory requirements mean anything when an executive branch agency decides compliance is too difficult or too politically fraught. The Epstein Files Transparency Act was as clear and unambiguous as legislation gets. It had specific deadlines, detailed requirements, and narrow exceptions. It passed with virtually no opposition. And yet here we are, weeks past the deadline, with less than 1% of the required materials released, and the responsible agency claiming no court can compel it to follow the law. It's openly defying. This is about more than Jeffrey Epstein or any particular individuals named in these files. This is about whether laws passed by Congress and signed by the president actually constrain executive branch behavior, or whether they're merely advisory pronouncements that agencies can choose to follow or ignore based on their own assessment of convenience and political consequences. The answer to that question will have profound implications for American democracy and the rule of law long after this particular controversy fades from the headlines.